So we're good. All right, so chapter 6, guys. A good topic, one that we covered last class with Tim Saya. This issue about malpractice. One, like I said, always gets my adrenaline going in the morning regarding potential malpractice. So the authors give us a case, starting on page 294. In terms of, there's not, some of you, I guess, Dee, I could ask you, did you have a chance to look at this? And the only reason you didn't is that, and Ping and Ming, I know you guys had me, last semester I taught income taxation and trust and estates. And this case deals with the Clifford case.
Okay.
So, Ping or Ming, did you
turns
get?
out we didn't need to read it.
Well, you didn't. You need to read it because this was a screw up.
Oh.
Did you guys have a chance to look at this? Any volunteers? What happened here? Peter's up for the task.
I guess the Horn, who was the attorney.
Who was the attorney? Just so, and let me just, Peter, before he goes, let me just explain what a Clifford Trust was. It's no longer, you can't form a Clifford Trust anymore. Let me just shut the door.
I mean, yeah.
You can. You just, if you're looking to be sued, set one up. It used to be where if you sit, Mr. Clifford set up a trust, and it became a court case, and Congress came back and essentially Mr. Clifford retained so many indicia of ownership over the trust. The court ruled that any income the trust generated, instead of being taxable to the trust where it had to file a Form 1041, would be taxable to the grantor, the person who set it up, because he retained such indicia of control. And then Congress came back in response to Clifford and said, look, you set up a trust, and as long as the term of the trust is in excess of 10 years, that the income would be taxable to the trust. And many people set up these trusts that go for 10 years and 1 day because they wanted to have the trust earn the money. And if the trust earned the money, it would be subject to a lower rate of tax than it had the individuals. And the individuals earn the money. So Clifford Trusts were very in vogue during the 40s, 50s, 60s, 70s. And then Congress in 1986 rewrote Code Section 673 and essentially said that you couldn't have these trusts anymore. I'm paraphrasing what Code Section 673. But again, this was very common. People set up these so-called Clifford Trusts that were 10 years and 1 day. And as long as they didn't maintain, overly maintain indicia of control, that it was taxable to the trust. Trusts had their own tax rates under Code Section 1, and you could save significant income tax dollars. All right? So that's by way of background. Here we have a taxpayer, probably didn't read about it in the internet. These are pre-internet days, but learned about the virtues of a Clifford Trust and wants to retain a professional to set up a Clifford Trust. So go from there, Peter.
Horn hired an attorney, and I think the attorney actually found out about, Horn found out about the attorney through a pamphlet that he advertised that he does Clifford trusts. So he hired him to do this Clifford Trust. And then at the end of the day, between the other professionals, the accountant, they hired other experts.
So picture if you will, the accountant says, hey, you gotta hire this attorney who's a real expert in setting these up. And the attorney, knowing his shortcomings, hired another expert, supposed expert, in setting these up. So you have an accountant and 2 attorneys who are involved in setting up this so-called Clifford Trust, which they did. Keep going.
And the IRS under audit found out that it wasn't.
So what was it funded with? In other words, you set up a trust and then you have to fund the trust with something.
A patent that he had developed through his
Yeah, they
Put it in for 5 years.
they put it in, but it was not an exclusive. They put it in a way where at any point they could retract, essentially retract the license. Look, don't worry about, for those who even, I'm never gonna ask a question on Wednesday's exam about what is a Clifford Trust or anything. The takeaway here is the attorney who set this up screwed it up, because you can't fund a Clifford Trust with inappropriate assets, and this was an inappropriate asset to fund a Clifford Trust. And the attorney claimed that there was no malpractice, right? And what does the court hold here?
That there was, because he should have known as an attorney in seeking out, experts. It was his responsibility as well, because he seeked out that he was liable. It's in his duties as a lawyer to basically know that.
Yeah, I mean, this seems, you were being retained, you were being paid X dollars per hour for your expertise. You should know what can and cannot fund a Clifford Trust.
He was trying to blame the other professional and say, no, well, it came from them.
Blaming other professionals, the only thing you can do if someone else, you can try to cross-sue them. So the fact that other professionals may have been derelict in their duties doesn't help you at all. The supposed expert, the person, this attorney, the guy who was from California, who was the supposed expert, I think he had never done one of these before, but
Yeah, he was in the year in or something.
yeah, he had no real expertise. So here's another message. Maybe this gets the B's point or others' point. The fact that someone has some letters after his or her name, or they hold themselves out as being truly experienced. Here, DeMonte, you really can be cynical, right? Because there's a lot of people out there who claim that they're real experts, but they've never done certain things. I see this with a lot of trial attorneys that they hold themselves out as seasoned veterans, but they haven't been in the courtroom for 5, 10, 15 years because they settle everything, and they really are unnerved about getting back into the courtroom. So they're more apt not to perhaps pursue your case as vigorously as they should because they're scared, they haven't been, and we know other people who do, they just play the game. Be careful, and you've got to ask real penetrating questions of your professionals.
Was the attorney, defendant an actual tax attorney in this case? Was he? Do you know?
The defendant, I don't think was, and he was just, and this is one of those where you should know your limitations, guys. When someone asks you questions, again, there's always a temptation to make a bigger fee, right? But sometimes you're really not cut out for certain things. And my only message to you is, one, don't take that person on as a client, or if you're really not the expert, and I've been there many times myself, what you might consider doing is saying to the client, listen, I can do this, but I'm gonna work with someone and work in conjunction with someone and try to learn the area, but do not just try to learn it and not get what you need done checked, all right? So just, that's a recipe for real disaster, all right? So, and if you're ever having an issue of like, should you, shouldn't you, there is a 6-volume series, something called Legal Accounting Malpractice, that has all the cases and how people, I mean, this is not something that, again, comes up once in a while. This comes up all the time. You constantly have clients who are frustrated, didn't get the results they wanted, and they're blaming you. And what do? They sue you. So on page 299, there's a discussion after this case, lawyer loses. There's a discussion. Tim raised this, and I know I had mentioned one of the elements of a malpractice suit, which is what, guys?
Damages.
Thank you. Viva called it damages, right? Damages. But it goes beyond just damages. On that, the bottom paragraph that extends to page 300, there's several things you gotta look for. The defendant owed a duty to the plaintiff, okay? Owed a duty, that means there had to be a professional relationship. The defendant, meaning the CPA, breached the duty. 3, the breach caused injury to the plaintiff, and this is what Tim pointed out on Wednesday. There's gotta be proximate cause. There's gotta be some sort of connection between whatever the services you were rendering and the injury, and then there's got to be damages. All right, so you need all 4. It's not, oh, you need 2 out of the 4 or 3 out of the 4. All 4 of these have to be met. And he talked about that you can have, it could be under what's called a tort theory, that someone committed a tort, or it could be contractual. Another contractual is that, hey, by signing your retainer letter, you agree contractually to deliver certain performance. And you can be sued on a breach of contract, or just a general tort theory that's saying, hey, you caused injury to us. They don't look to any sort of contractual. Either, I think that's semantics. Either way, you run the risk of being sued under either theory. The authors explain in detail about the need to communicate to clients, all sorts of things. I think this is well worth reading. We will go through, beginning on problem 6-1, how this plays out. I guess, let me just take a moment of your time. I've been immersed on many occasions now as an expert witness, both for defense and on plaintiff sides on malpractice cases. I was at, on Thursday, what's today, Saturday? Thursday, I was in New York City Thursday morning, and the client is suing one of the big accounting firms because the client was involved in a tax shelter. And we were strategizing because they were going to go to a deposition later in the day, so I met them, the plaintiff's attorney, for breakfast on Thursday morning. And just things that people do. Major accounting firm, they charged $18 million in fees, right? That they didn't really tell the client. They camouflaged their fees in the form of, to the client, when you buy into this hedging transaction, you're gonna pay X dollars. But unbeknownst to the client is, they weren't really paying that for the hedging transaction. They were paying that as part of the professional fee to the accounting firm. Do you think the accounting firm, when they prepared the tax return, took it as a deduction? And the answer is no, because they were camouflaging it. But now it's come to light. There's actual email exchanges and documentation that makes clear this was the fee the accounting firm was receiving. How good or bad will it look in front of a jury if it ever gets that far, where you charge a fee, but you don't deduct it because you don't want the client to know about it? So a fee that normally you would be deducting, right? $18 million is a pretty big deduction, right? But you don't deduct it purposely because you don't want the client to find out about it. Is that going to be well received by a jury, that you purposely camouflage your own acts, and not only did you overcharge the client, or at least didn't disclose it, but then you don't even put it on the tax return? These are ways people, and I'm telling you, the amount of monies and fees, this was a major accounting firm that they were making, and it just went up the chain where everyone was willing at the accounting firm to close their eyes to this because it was such a profit center, and they could not resist the monies that were coming in as they were coming in. So, just, it was an interesting dynamic. Now, if you want my story, do you want my story? So, if it ever happens to you, I'm a survivor. No one here has been sued, right? to date? Oh, yeah, Frank, all right, so, if and when you ever get sued, let me just point out, hopefully you will survive it. I will give you the story. I never thought it would result in a lawsuit for 100 different reasons. And client comes in, I'll give you the quick factual background. Client comes in, she and her husband, and he is 22 years her senior, right? Second marriage for both. He has children from his first marriage. She has a child from her first marriage. We're gonna have the visual. And they want to do their estate planning, which is always kind of dicey because anytime it's a second marriage. And what do I do first thing, guys? What do I make sure I get? Disclosure and a written conflict of interest. So, and my notes, I had the words all in caps, dual representation with 3 asterisks, and I also secure, I give them the letter that day that they return later, that week, that says, consider getting separate legal counsel. So I'm trying to do it by the books, listening to my own words. This goes back over 10 years ago, but okay. And what happened? I said to them in my cover letter, who owns title to your house? Whose name do you want it in? We should consider this. Okay, because as most of you know, a will controls your assets in your own name, but if it's in joint name, how does it go? By operation of law. So that may not be what they want because it's a second marriage and they are not commingling their assets. And they check their deed, and much to their surprise, it's in joint name. And the wife, you may find this, she's 22 years his junior. She's the breadwinner, okay, in the family. She is the one bringing all the assets, and she said, and he agrees, it should really have been in the wife's name. They don't know how it was put in joint name, and I said, I'll prepare a new deed, changing it to the wife's name, and they then tell me to switch their estate planning so that he will get a life estate in that house, okay? So in other words, but I have to tell you, if you met my client, the gentleman, he was so happy about life in general because for the last 20, 30 years, he's been living a very good life because his wife is a superstar rainmaker, and he's now in his late 70s, and life is good. His wife is providing and you think she's gonna say, do you think he would ever say no to what she wanted? And the answer is, of course not, because he knew where his bread was buttered, and he was never gonna be on the streets. And look, he's 70, he's in his late 70s, she's 20 years his junior. Is he mentally thinking that she may predecease him? Anyone here thinking? In his mind, it's written in the stars, he will predecease her and life will move on. Right. Do I have to tell you what's going to happen next?
She dies.
She learned she has ovarian cancer, okay, which is not a good disease. And they decide they're going to move. So the house that I changed the title to her name, they hire a friend to change. They're going to move because this house is a multi-million-dollar house. They're going to move to something that after her death, if she does predecease him, he can manage. So they have a friend do a new deed, and they move into this new townhouse, and a year later, write the script. She dies, okay? Okay, so now her will says the husband has a life estate in the house, but what happens 2 weeks after his wife dies? And think about what you know about men in general and what we will do.
Got a new girlfriend?
A new trophy.
Say again?
A new trophy.
He finds a girlfriend,
Yeah.
okay? And
Why was she with him in the first place? She's 22 years his junior.
I
She makes
can't-
the money. What does she need him for?
I can't answer, it's beyond my pay grade. All right, long story short, not only that, her daughter wants to get the tangible personal property that's located at the house that was her mother's. She wants to get the jewelry, whatever, and she pulls up with a U-Haul with no permission and goes into the house and takes things out, okay? So does that look like it's good between stepdaughter and stepfather? No, not. But you can understand exactly, like he's now an elderly guy and he needs companionship, okay? So let's not sit in judgment, okay? And I understand the daughter too, wanting to get her mother's possessions. So we understand why this is butting heads. But who are you gonna blame in this situation? Okay? Because he has told his daughters for the last 20 years that he is the breadwinner. Okay, so and his daughters don't understand, why does dad not own the house? Like why does he have a life estate? So that has frustration on their part. Like, dad doesn't own the house. Why could that? Dad's made all this money. Why doesn't he own the house? All right. So what happens? I get served with a $2 million lawsuit because dad is out of the house because I changed the deed to the house that he's not even living in. Remember, in between, there was another house purchased where he could have, there's certain rights you have in New Jersey, he could have insisted that it be put in joint name, but he wasn't insisting. $2 million lawsuit, okay, that he is deprived of his livelihood. If you read the complaint, it was projected as if he were living on the streets. Meanwhile, anyone in this room, I think, would have changed places because he had a palatial townhouse, gorgeous. And if you read the complaint, Solar was responsible for the destitute of this man, all right? Do you want to tell me what happens now? So I'm not a happy camper, okay? So I just want to, if you get sued or when you get sued, guys, I am telling you, you will have this. First, you gotta, first and foremost, breathe, okay? Because you're like so anguished by the whole thing, like, and this is, I really thought I had done everything. Sometimes you get into a car accident, and what do you think to yourself? Can I just get those 10 seconds back because you would redo things, right? This wasn't one of those where I'd say, could I just do it again? Because I wasn't, yes, I would not have taken them as clients. But short of that, it's not like one of those errors you make where you just wish you could correct the errors. But putting that issue aside, you will find, if and when you get sued, that like sometimes it will consume you. And then sometimes like there'll be times like it won't even be on your brain, like it comes and it goes, all right? In New Jersey, when there's a lawsuit, there's forced mediation, okay, where you have to you must try mediation before anything can proceed, which is not a bad idea. Anyway, but first I had to answer interrogatories and all that. So I want to give you a quick visual because I think it helps. So we have to meet with the mediator, and my former client and his attorney's on this side of the table. So we have two people here and here. We have the mediator here, and we have myself, my colleague, and my attorney. So there's 3 of us here, 2 of us here, and the mediator right here. The mediator comes in, he says, my name is Kevin, I've been doing this for 10 years. I know the dynamics of all this, and I want everyone to keep their emotions in check. I think we can protect. Gives a whole spiel, 10 minutes. He gets done, and my former client says, do you mind if I have a word or two? And he looks around, he says, you gave a great speech, Kevin. I really appreciate everything you had to say. But the one thing you forgot to do is to introduce me to the 3 gentlemen sitting across from me. He really wasn't there. Like, remember, now he's early 80s, okay? Mentally, he's not quite with the program. He had no idea who I was anymore. So with that, his attorney like pushes him back down into the seat and says, "Can we have a break?" And with that, the mediator disappears with them, and I think read them the Ryan Act like, "Are you really bringing a lawsuit here? How much do you think we settle this case for, guys?" Because, by the way, Peter, come on.
There's no such thing as zero.
You know what?
Attorney fees alone.
Like
Well-
50, 100,000?
You can't win, by the way, if you get sued. Let me just make this, you can't win because if you say, justice must be done, I'm not paying a dime to that scoundrel, the legal fees will get racked up, and when you apply for malpractice, there's something called a run total score, and they will look at that score, and you look like a recalcitrant practitioner, and your premiums will go through the roof. So there's no winning here. So what do we settle for? Because we gotta make this go away, because if you don't, again, there's no winning. And by the way, Peter, aside from that, you can spend weeks, and are you being paid for your time? Yeah. So at some point, you just say, what can we settle for and move on?
10 to 30% of your income, of the lawsuit,
So give me a number. I'm not sure paying what number.
which is,
50,000.
Yeah,
50,000,
50 or
100,000 at the
100.
most.
Well, they came back and they said they would take, as soon as they came back from the mediator, they said, we'll take 90,000 with flexibility, which means give us a counter offer. We gave a 20,000 counter offer, and they said, a little more please, and we just said, make this go away for 30,000. And that was the final number. So.
It's like 1.5% of what they were.
But let it be said, and by the way, you will, I can't say this for sure, many people I know who get divorced hate not only their former spouse, but they hate the attorney who represented their former spouse. All right? And I sort of harbored some real misgivings against the attorney who, like, ambulance chaser, why did he bring this case? Life is, I was talking about strange journeys. About 6 years ago, a new law firm moved into my floor of the building. Who was there? That former attorney. And we've been friendly ever since, and periodically he'll use me on a case. So you just never know where life is. The plaintiff's attorney for my former client, you just don't know where life is going to take you. So don't burn bridges, because despite my kind of disdain for him, he was just trying to make a buck. And
Strictly business.
That's what he would say. Strictly, nothing personal. So anyway, I survived. My point in sharing that story is, I don't love sharing that story, but things happen, guys, and you can do everything in your, control to try to avoid that, but sometimes just your time kind of thing. So know that. Look at problem 6-1. Lawyer prepared an estate plan for a client that involves a revocable trust and a will designed to maximize the benefit of the marital deduction for the estates of both client and client spouse. Absent tax law, client would have preferred to leave all the property outright. 1 year after client executed all the relevant documents, client repeals the estate tax. So picture you have a case with a husband and wife. Husband's worth, I'm going to make this up, $15 million, just to make it easy here. 15 million, and the exemption amount is 11 million. And he decides that he's gonna put it in a trust because he's been told that because of the estate tax laws, using this trust is gonna be advantageous to secure something called the marital deduction. Again, for Wednesday, don't worry about anything about tax law per se. If there's an issue, you don't have to worry about the tax law. I'm worried about the ethics issues, okay? So he sets up a trust on the husband's demise for the benefit of the wife. The law is repealed, and now the money could have just gone to the wife outright instead of going in trust. but that's not what the terms of the will say. So the question is, does the lawyer have a duty to advise client of legislative change and its effect on client's will, trust, or related matters? So, and it could be a lawyer or accountant. You know, as the law changes, guys, tax laws change. Do you have an ongoing duty to your clients, Nick?
Say, yeah. I think it would depend on the retainer.
Right? They depend on a retainer. Brian, what do you think?
I think yes.
Well, and then the second part of the question does say, would it matter if you had an ongoing relationship or if the lawyer's preparation of the will and trust instead of representing a one-time engagement? And I think you guys are alluding, your retainer letter, I mean, I'm gonna tell you what you should do professionally as a CPA or a lawyer, is that when you're done providing services, theoretically, you're supposed to send a disengagement letter saying, I've now performed my services, and going forward, I'm not representing you. But is that something that you really want to send out? Because it sort of says, well, good luck to you, right? Which is not a way to build I'm just telling you though, theoretically that would be your best avenue of protection, but that's probably not something you're apt to do. So having said that, your representation letter shouldn't make no representations, no pun intended, saying that you'll keep clients updated as to status changes in the law. So in terms of your notes, if you continue to represent the client in other business matters, I think you open yourself up that there's an expectation on the part of the client that you would keep them updated. If you don't, as long as you have a good retainer letter that makes the statement that you will not keep them updated, you should be okay. Because it can't be perpetual, right, Nick? Seeing facts as A above, except client called lawyer when client heard about that the estate tax changes were being considered. The lawyer said, I'll let you know if anything important happens. John, are you digging yourself in here?
I think you are.
Yeah. If the lawyer leaves it open-ended or accountant leaves it open-ended saying, I'll keep you posted, then you take on that responsibility. I've said this before, I'll say it again. Be careful in this day and age where you can be taped. Because I was involved in a case where the lawyer said, I'll look into it, and didn't. And much to his chagrin, the client died, but someone had that I'll let you know on tape, and that was game over for the attorney.
So he is.
I'm sorry?
What's the then?
B is, that's a problem. You have malpractice exposure. C, if you think the lawyer has a duty to advise client of the estate tax repeal in A and B above, how should the lawyer advise the client? So, assuming you agree, Kevin, that the lawyer does, what should the lawyer do in terms of keeping the client posted?
You mean what methods he should use to keep him posted? Well, you could do it in writing, in a letter, you send it by mail or by email.
Yeah, some
phone
sort
calls,
of
yeah.
written response is required, right? Right? Assuming, you know, how many of you guys send to your clients, or does your firm send client update letters if there's a major change in the law? Can I tell you a story? I do. If you want, what is the famous picture? Which president where he has the picture? Humphreys, Hoover, the famous newspaper where he's holding which president won?
Truman.
Truman,
Versus
right?
Dewey.
Truman versus Dewey, because the newspaper said Dewey wins. All right, so if you want the solid version of that, now look, whether you like Trump or you like Clinton, what did the polls say the day before the election?
Clinton would win.
Hillary wins. All right. I mean, not only Hillary wins, what were the odds?
Right, she won.
Hillary wins in a landslide.
Well, not that she was going to win in a landslide. I think the pundit said there was 80% chance, 90% chance of her winning, right? So what do you do in that case? And you want to be the first kid on the block with a update letter to your clients? You have 1,500 letters ready to go with Hillary. This is she's won the election, and this is what we expect the laws to be for the foreseeable future, right?
I bet you they had to throw all of that out.
It gets worse. My secretary decides she's a Hillary fan, and she's like, I'm going to start posting. She didn't say I'm going to. She posted like 50. Her name is Gay, and I said, Gay, what are you doing? She said, oh, I want to take care of this. I'm going to save some time for tomorrow. Stop. All right. Anyway.
What did she post?
She started putting postage and sealing the envelopes the day before the election.
To your clients?
Yeah. I want to keep my clients updated. But I mean,
But with the correct information.
I wasn't sending them out the day of the election. I was going to wait because they didn't say 100% chance of winning. They said 80% chance.
And
So
even if they did, that would be subject to change.
well, anyway, need I say, this is on the good paper and all the other stuff. 1,500 letters went into recycling, and then I sent out a Trump version of I didn't have a Trump version ready. I created a Trump version of the letter, and off it went a week later. All right, but the point is, you should keep your clients updated, but you should not be like me. Don't follow my lead. Wait until you know what the actual law may be, as opposed to presuming what it would be. It's not my nature to gamble, and I guess that was a gamble of sorts. But all right, assume lawyer had a duty to advise client of the change of the law in Part A and did not do so. Client dies a year later, and as part of the client's estate, ends up in a marital trust. Okay, so of the 15 million, 4 million goes into what's called a marital trust. 11 million goes into what's called a bypass trust, in which client spouse only has a life estate. So the wife is not a happy camper, right? Because she would have preferred getting it outright. Now she may have to sit across the table from a trustee, and you can't even say what the advantages are. There are none. Is the lawyer potentially liable for failing to advise the client of the change of the law? If so, to whom? If so, what would be the measure of damages? There's the D word, right? So V, Dixie, you're the frustrated wives.
We totally sue the lawyer.
Is that even if he or she didn't have their initials after their name?
ESQ works.
All right. Dixie, you going after the lawyer?
I'm not sure. I maybe not.
Hey, this is millions.
I know.
I-
don't care.
I know you didn't ask me, but I would side with V.
You're going after that lawyer.
Yes. Because he didn't keep them updated with the information until he died.
And Mike, you're mad?
I don't know.
You're going to go after the lawyer too?
Yeah.
Right. But do you have something called privity? What's privity? Anyone know?
The right to get information or?
What does it sound like before? I see Viva, she's Googling it.
It's the right to.
Let's get the definition.
Oh,
Or do you have the definition?
No, I don't. I'm just thinking about what it might be.
Just say it loudly, Viva.
A relation between two parties that is recognized by law, such as that of blood, lease, or service.
Right, it's a relationship by by blood, some sort of relationship. Let me give you a good example of this. I hope it's a good example. Let's suppose, Ming, I'm going to have you say that you're a widow, okay? And you're worth $10 million, and you go to a lawyer, and you have 3 children, and the lawyer misdrafts your will. And instead of leaving it to A, B, and C, your 3 children, only leaves your $10 million to A, and B and C are upset, right? Because they expected 1/3 of the estate. But remember, B and C did not hire your attorney. Let's suppose you had hired me to be your attorney, okay? Could B and C sue me? Do they have any privity with me? Because remember, generally you can only sue the professional you hire. Everyone agree? You can only sue a professional you hire. But B and C never hired me, right? Everyone agree? They never. So what? I don't know who they are. I don't know who they are across. Can they sue me? Can they sue me?
They suffer damages because of,
But not because of our professional relationship.
but the mom is dead.
They can sue the sister. Or A.
Yeah, they can sue
So
the
it has to
bundles.
go
Hold
to
on,
the
but
next.
can they sue the profession?
Yeah, they should be
We
able
could
to.
try.
Would they be successful?
No.
Probably not.
I think so.
They would, because there's a privity. And what you'll see at the last part of this chapter is that courts used to not let you sue, would not let B and C sue me, because there was no relationship. But they've come to acknowledge that there was an expectation on the part of B and C, a natural expectation, that the professional would have done this service on their mother's behalf. And because they are in privity with their mother, in other words, they have that relationship of being mother-daughter, or mother-son, whatever the children are, that relationship, they are in privity with each other, and therefore there can be a suit. That there is a privity there. But for example, if a lawyer renders services to Walmart, okay, it screws up, and Walmart doesn't get sufficient number of rakes for the spring season because the lawyer screwed up the contract. I, as a customer, can't sue the lawyer and say, hey, I have damages here. I can't get the appropriate rake because I'm not in privity. So there has to be some real relationship. People can't just sue professionals who screw up unless there's some sort of privity relationship. All right? So anyway, that was a digression from the issue of can V and Dixie sue this attorney, but it begs the question, what are your damages, V? What are your damages, Dixie?
Millions of dollars?
Is it?
Well,
What are the lactose?
okay, a life estate, we only get to use it as long as we're alive. We can't pass it on to our boyfriends or our stepchildren or our future
But-
blood children.
How does that affect you?
Well, you should be able to use the money, right, to do
Well,
whatever you
the
want.
point is, you recall our fact pattern. We had V's husband was worth $15 million. He dies, puts $4 million into the marital trust, 11 into this bypass trust. And yes, V has a life estate. Okay. Now, depending on V's life, how old she is now, actuarially, her life estate, right? The older she is, the smaller the life estate is. Agreed? If V were in her 90s, her life estate might be worth 10%. If V's in her 20s, her life estate might be worth 80%, right? So we certainly want to figure out what is the numerical value of a life estate, right? And just using these numbers, let's just suppose if her actual interest was 40% of this life estate, and the trust had 15 million, that means that her actual interest is 6 million, right? So I don't know if you could get more than $9 million of damages, because you certainly are entitled to 6 million. You might say you're entitled to more because that 6 million, and it would depend on your health and other things. The point the authors are raising, we're not going to be able to quantify this and tell you definitively what the damages are. And this is a point Tim say, I mean, damages are really hard to compute. Everyone agree? Not easy to compute. And this is a telltale example of hard to compute damages. This Dixie or V may be very upset emotionally that they're going to have to deal with a trustee for the rest of their lives and all sorts of parade of horribles. And then the attorney, lawyer's going to say, hey, look, she's gonna get a nice stream of income, there are all sorts of things. So you can understand, not gonna be easy to resolve. In question 8, in parts A through C, would the lawyer have done, what should the lawyer have done to avoid having a duty to update the client about changes in the law? And this, ideally, in the retainer letter and or a disengagement letter. Okay, but again, disengagement letters, I don't know any attorney who really sends them out. And this is true for CPAs too. At any time you stop representing, you theoretically should send out that letter. I am assuming no one here, none of your firms send out these letters, right?
This letter we can get online.
What was that, Viva?
This letter can be got online.
I mean, I would send it formally. You don't have to send it certified mail, but. 6-2, elderly client comes to attorney for estate planning. Attorney persuades client to purchase annuities on which the client earns significant commission. Now, what's wrong with that? Just stop reading.
Self-serving.
Well, self-dealing. Like, should you remember from chapter 3? Chapter 3, should you be having business dealings with your clients, guys? That's a recipe for potential conflict of interest, right? If you do, should you disclose your commissions? If you don't, then you're being duplicitous. We got issues there. The following year, the client needs funds for medical expenses, so she sells the annuity for substantial penalty and incurs substantial penalties. Can clients sue attorney for malpractice or breach of fiduciary duty? In this case, Trevor, what do you think?
No.
Can't sue.
No.
Why not?
It says that the attorney did disclose, so
Where does it say that?
I think maybe I read something different.
Maybe you heard me mention that he should disclose.
Well, if you didn't, then I'm gonna reverse my answer.
I mean, even if you, first of all, if you don't disclose, right, you got problems. If you do disclose, the person really should get separate legal counsel to decide if that's a good deal or not, right? You can't win here. You cannot win here. And I think the client here would have potential breach of duty or malpractice suit. Certainly my brethren attorney out there could easily find a case, and if not find a legitimate case, enough of something that you would end up settling, right? If anything's a little bit beyond frivolous, they will sue you and hope that you just settle, right, guys? So don't give an opening like this. The fact you disclose that you're getting commissions doesn't give you a green light, because the idea may be, hey, whatever commissions you get, is that what's ordinarily charged, or is it $1 more than it's ordinarily charged? Is it even right for a person this age to be buying annuities? Did you have them buy too much in the way of annuities because they lack liquidity? So you put them in a really bad situation. So I think just bad news all the way around. Anytime you go into a deal with your client, I don't even care if it's a neighbor of yours. You know, some of the things that we just read about in the last chapter, where you have an existing personal relationship, don't go there, all right? Some of these things, guys, I'm hoping you take beyond Wednesday outside the classroom. 6-3, in connection with the filing of a tax return, client retains lawyer to provide a written opinion supporting client's favorable position on an uncertain issue on the return. Lawyer provides a substantial authority opinion, right, guys? Sounds good to me for the moment, which clearly explains what substantial authority means. Client does not read the opinion, typical client, right, guys? But takes the position the lawyer advises on the return. Client is audited and the IRS disagrees with the position taken on the return. Following an unsuccessful administrative appeal and the filing of a petition in tax court, client settles the case for the tax deficiency asserted plus interest. No penalty is imposed. Is the lawyer liable to claim for malpractice? If so, what is the measure of damages? Okay, so this could happen to you. Think hard. This is a good problem. This could really happen in your practice. So take a moment, reread the problem, take 1 minute, see how you come out here. Everyone's got a, it's a great problem. So we're gonna ask by a show of hands, and you can't fence it, okay? Either you say, we'll be like the Roman gladiators, thumbs up or thumbs down, okay? So you gotta do one or the other. Is the attorney liable for malpractice, show of hands? Is the attorney not? Hold on. So let's try that one more time. Who says liable? Anyone? Hi, 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 hi. To this side of the room, Devontae, you say not. Who says not? And those who say liable. Let me go down the road here. Nick, why?
The client should rely on the opinion, whether they read it or not.
So you're holding the lawyer accountable. Ryan?
Yeah, same thing.
John?
Yeah, I don't know, I was kind of on the fence, so I just need more yes. Because I feel like you could kind of sue for almost anything.
But for exam purposes, don't put, well, you can sue for anything, okay? That's not gonna get you a good response. I need legitimate, okay? For the exam, we're gonna be in a different world where only legitimate passes. So
you're gonna give us black and white situations? No, right?
you need to legitimately justify your answer, not like anyone can be sued for anything kind of thing.
And the answer just be it depends for every question.
Yeah. So in this case, guys, I'm gonna actually, Kevin, be very strong in and not equivocal at all. This is not malpractice, okay? Hey, the person issued a substantial authority opinion, right? You are not a guarantor of outcomes, right? You just said that there's a substantial authority, meaning there's a 40% likelihood. Guess what? There's a 60% likelihood that you might lose and the taxpayer lost, right? Should you, I mean, your role as a professional is not to guarantee outcomes. It's to, help clients make decisions what's right or what's possible. And in this case, you offered an opinion and it's not incorrect. It was good professional advice, right? It didn't say that this bar hadn't been met. It said there was substantial authority. Maybe the IRS had compelling authority. So I don't think, Nick, Brian, John, I don't think you could, nor should you, because this may be you, render an opinion, you should not be held accountable for this. This was good tax advice.
Question. You just mentioned, some kind, maybe they just sue, doesn't matter is, you win or not. So they just want a settlement, just like you say.
Absolutely.
Anything, I can get.
But again, there's got to be a reasonable basis, and I would argue, even Bob was truly, that's his name. Bob was my the guy who I now share office space with. But even Bob would not take a case like this. Okay, I mean, they need something to go after. A little something. There's nothing, in my opinion, there's nothing here. Nothing that a practitioner had done wrong. I don't know what measure of damages would be here, because all right? So problem 6-4. Lawyer is hired by a new client to advise on whether a tax shelter is being marketed to client will work. A lawyer tells client that the tax shelter probably will not work, and the client could then be liable for penalties. So client does not invest in the shelter. Okay, good. Years later, other taxpayers are in court with the same shelter, and the case is consistently fined for taxpayers. So this shelter apparently, notwithstanding the lawyer's original misgiving, does work. Can client sue the lawyer for malpractice? The plot thickens. And aside from the answer thing that, well, you can be sued for anything, just pretend it's the exam. So you can't just write that. Andrew, what do you think? Can you be sued for this?
I'm leaning towards shouldn't be sued for this, but this one's tough.
Upper tier John, you have an opinion here?
I feel like the lawyer would probably be okay in this, because the court isn't exactly known for punishing lawyers for discouraging their clients for jumping headfirst into tax shelters.
Remember though, it's probably most tort actions like this, just so you know, typically held in front of a jury, okay? So I just want to share that tidbit. So they may or may not know much about tax shelters or whatnot. So I want to, and that's a tough, I don't know if I would put that down on an exam. I'd probably say not.
I think not. I think it's similar to the other one, about an opinion, opinion doesn't have to be correct.
And Kevin, you were going to say, and then Trevor?
I was gonna say basically the same thing, as long as you issue an opinion that it's most likely than not, most likely gonna happen, and it will be negative, then what would be the, problem? He covered himself.
And Trevor, you were going to say?
I was gonna say that the lawyer doesn't point to any authority or any, he just says, no, it's not gonna work, kind of. So the client relied on that and then lost out, so I would say it is, there's malpractice.
Because why? I'm sorry.
Sorry?
Why is there malpractice? I'm sorry, I didn't connect.
Because he didn't really, he just said no, he didn't really give a reason for it. There's no, for example.
Suppose he did. Suppose he put his rationale in writing. Would
Well,
you be less after?
Yeah, because like you said before, he's not a guarantor of outcomes, so then in that case.
There is, and look, I think, if you don't mind me saying, all of us are a little biased. See it through the eyes of the professional, I hope so. We hope that our brethren, lawyers and accountants don't get sued for this kind of stuff, because we can all, I like to think, picture ourselves doing the exact same thing, right? And the fact that the IRS apparently, it's clear, brought suits against people who did use this tax shelter, right? Because it says right here, years later, other taxpayers are in court. The IRS did not think this was legit, right? So that to me is an indicia of, hey, maybe the IRS won in court for, the other taxpayers won, but the IRS did not look fondly upon these tax shelters. So ultimately, maybe the taxpayers did prevail, but there was a battle. So I don't think the fact that you didn't, we talked about guarantors, you didn't say this would never ever work. You used the word probably, whether it be in writing or orally, but that doesn't mean you said, hey, this will never ever work. So I think this should pass muster, meaning that the professional should not be sued in this context.
Does it matter that he didn't lose money?
He did what?
Lose money,
He did. You could argue.
He didn't make money.
Yeah, but people sue all the time for missed opportunities.
Okay.
And as Tim Sayo would say, try to put a dollar figure on that. And by the way, when they brought that $2 million suit against me, there was all sorts of damages associated with that, missed opportunities he would have owned. It's just filler to try to get your blood pressure up. 6-5. In the mail this week, CPA received a short memo from business acquaintance outlining the details of an oil and gas drilling partnership designed to produce generous tax deductions for limited partner investors. CPA approached client, the drummer, who had made a fortune of playing in a rock band, with a proposal. When this client expressed interest, CPA reminded client that CPA recommended that client ask lawyer for legal advice about the tax consequences of the transaction. Lawyer provided an oral, more likely than not opinion in the circumstances described below. Lawyer asked client if client expected to make money on the investment before taking taxes into action. Client said, sure, CPA told me I can make lots of money on this deal if everything goes right. He showed me some impressive projections. Lawyer did not ask to see or review the projections, but discussed the transaction generally with the client, pointing out the transaction met the technical requirements of the code for desired tax treatment, but that any investment that generated large tax deductions could be subject to challenge on economic substance grounds, especially if the client did not reasonably believe he could make a before-tax profit. Client then said, yes, I understand. Lawyer responded, if you intend to make and do make a healthy before-tax profit, in my opinion, you are more likely than not to get whatever tax treatment you want, even if the IRS challenges you. Let's take a step back before you read the actual problem. So, does everyone have this scenario? There's a code section now in the code 77010, code section 77010, that says that transactions require economic substance to be respected. You can't, if a transaction lacks economic substance, it will not be respected, all right? And we also have the definition of a tax shelter in 6662 D2 that we've looked at. So it's not unsurprising, to the contrary. In fact, again, Thursday morning over breakfast, when I'm talking about experts' reports, the accounting firm and the law firm with the client kept emphasizing, oh, you're gonna enter into this transaction for profit, right? Wink, wink, right? Everyone around the table wanted this to result in theoretically an economic profit. The question is, there's also, how do I say it? Most clients who went into this, what do you think their chief objective was to go into a tax shelter? Secure tax losses, right? If they made money, right, Devontae, that would have been icing on the cake. Agreed? All right? But were they going in to make money? No. So for every 1,000 tax shelters, how many made money? 0. I'm telling you, not a single one. You know, if they were smart, they would have had 1 or 2 people who actually made money when they created these. But no one, to my knowledge, not a single person of the thousands that were put together, no one made money. Because it was all controlled, and this is public knowledge, you can Google this. Deutsche Bank controlled these hedging transactions, and they were on both sides, so they could manipulate it so they made their fee, but by making their fee, no one ever made money. But, and did clients really, and in fairness to the clients, if you have a Big 4 accounting firm and some of the biggest New York law firms in the country telling you, hey, your expertise is in the area of software, but we're telling you, you could make money in this area. Now, you may say that is, how do I say, just wishful thinking, but, you know, if you're in that world, particularly in the world of in .coms where sometimes things hit, many don't, but once in a while you get a real winner, and if you get a real winner like Facebook, you just made 1,000-fold your money, or Bitcoins, or, you know, pick the thing that, you know, we can all pick winners in retrospect, like horse racing. So when we read this problem, and the lawyer, and this is not just any lawyer, let's just suppose this is from one of the top New York law firms, And the accounting for this person, one of the top accounting firms says, oh, you're gonna make, aren't you gonna make money? And it's sort of like the accountant said, and now the lawyer's just kind of trying to affirm. So I'm just letting you know, this fact pattern, Linda and Michael, who put together this textbook, this was truly the case for thousands of taxpayers, just what you're reading here. Okay. Subsequently, the client is audited by the IRS, receives a notice of deficiency, goes to tax court, and loses on the ground the transaction lacked economic substance. Is the lawyer liable to client in malpractice? Is the lawyer going to be liable for malpractice? Payne, you say no. Why not?
Because you speak out.
Say again?
You speak out.
I don't know what you mean by speak out.
You are more likely than not to get the tax treatment you want.
So is the lawyer liable or not? I'm not sure how to read what you just said. Is the lawyer liable?
No, it's not liable because
Why not?
it will be explained.
And Ming, do you agree? Not liable? Thumbs up? Not liable?
He just provided the oral, not the written.
The fact that it's oral, not written, that protects or doesn't protect. In other words, guys, for the exam, you got to draw conclusions, right? You can't just say, was it oral or written, or what conclusion do you draw if this were an exam question? What? Show of hands. Lawyer liable? Hands up. Lawyer not liable? I see some. Not liable? Why not? Suppose I told you that there are 1,000 tax shelters like this and not a single one prevailed. Was he right in saying more likely than not that it would prevail? Wasn't his legal analysis incorrect? Didn't the lawyer say this is more likely than not to succeed? Well, we have 1,000 test cases, right? 1,000 investors. Not a single one won. Doesn't that say that your analysis lawyer was wrong? He didn't guarantee an outcome, but he did say for every 100 cases, 51 people would prevail, 49 would lose, right? Theoretically. But 100% lost. That's not a good track record, right? I think the lawyer has some real issues here, guys.
Does it say here that 100% lost?
Yeah.
Well, I'm letting you know that 100% did lose.
Oh,
If I told you that, would that help?
yeah. Then that would definitely help, yeah, please.
I really
Please do
think
tell us that on the exam.
All right. Question B. Same as A, except that the lawyer's opinion is in writing and appears to satisfy the written rules of advice of Circular 230. That should not change the outcome, right? Whether it's oral or writing. And even if you found and you wrote a very, I'm telling you guys, the written opinions I read, I don't want to exaggerate, they're a few inches thick of just eloquence of why taxpayers should prevail on these transactions. Notwithstanding that hundreds of pages are spelled out here, there's just words, toner on a page. And the fact that a big law firm says it doesn't get the outcome that you want. I was telling the lawyers, without getting into much detail, I was telling, juries are apt to go to sleep, right? And they don't find these things very interesting. So I said they might consider bringing the jury in because doctors in the 1800s, in the 1800s and early 1900s to cure women hysteria. If you guys can read up on the history of that, they used interesting ways to convince people, oh, we're experts. We can solve your hysteria problems. And they were experts, and they were able to get away with some really lewd behavior under the auspices of they were experts. So I was telling them that, hey, got to keep your jury involved. So come up with some interesting fact patterns beyond tax. Okay, on problem C. Same facts as B, but the written opinion, instead of being more likely than not, states, in my opinion, the tax treatment you want is supported by substantial authority. Assuming that the lawyer's conclusion that there was substantial authority was correct as a matter of law, and the lawyer explained to client what substantial authority meant. So in some way or form, if the lawyer was spot on that there was substantial authority, would this in some way absolve the lawyer of potential malpractice? Peter, what do you think?
No.
Why no?
Because it's dealing with tax shelter.
Yeah, it's dealing with a tax shelter. He's using the wrong standard. So even if he's right that there is substantial authority, he's supposed to, in order for the taxpayer to avoid penalties, it's got to be more likely than not, right? So he's using the wrong standard, or she's using the wrong standard. So that's not a good sign. That's a clear sign of potential malpractice, right? Question D. Suppose the client is and has always been a resident of Arizona, and the lawyer is a resident of Connecticut, and maintains an office in Connecticut and is admitted to practice in Connecticut, but not in Arizona. Under the facts of this problem, do you think the court in Arizona should have jurisdiction over a malpractice action filed by client against lawyer? So this is a jurisdictional issue. Don't look for this on the exam, okay? Because I'm more interested in, do you know if there's liability, not jurisdictional issue. But just for, I've alluded to this question before, or alluded to this before. Can you be sued in Arizona under these fact pattern thing? What do you think? Anyone? Arizona? Yes? No? The lawyer's absolutely in Connecticut, but Viva, if you take on a client in Arizona, don't you think you've exposed yourself to being sued in Arizona? That's what I'm warning everyone here, because we all want clients, everyone agree? But that comes with a risk. And if you make a mistake, it's bad enough when you got to deal with it. And I told you, well, if I didn't, that my malpractice suit, the opposing counsel was 5 miles away, now next door, but that's a different issue. But my point is, still very painful. But imagine if I had to travel for mediation and other things to Arizona and confront that whole issue. And the notion is, hey, you chose to have a client in Arizona, that comes with the territory, no pun intended. All right, so be careful, or at least know what you're getting yourself into if you have clients spread throughout the country, guys. All right, damages, that's an issue we spoke about before. Here, chapter 6 is not a long chapter, guys. It's a nice summary of things to consider, if you haven't. So damages, always very hard to quantify. Sometimes it's fairly clear. I mean, not often, but sometimes. For example, just to use a very simple example, is someone dies and they owned stock in J&J, and the stock is worth $100 million. It's a widower died with stock at J&J worth $100 million. And some of you are familiar, there's Code Section 2032 that if the value of the estate goes down within 6 months, you can use something called the alternate valuation date. And if the $100 million worth of stock had declined to, say, 80 million, and the accountant had used the 100 million date of death value instead of the 80 million alternate valuation date, hey, there's a $20 million excess, right? The estate tax rate is 40%, and the statute of limitations, so you can, the damage is there, $8 million, right? Game over. Malpractice company will say, hopefully you're fully covered, but whatever your coverage is, but you're gonna end up owing $8 million, agreed? But often, with tax shelters and other cases, rarely that easy. So sometimes damages can be additional tax. You turn the page, the cost of corrective action. Suppose you make a mistake and now your former client has to retain legal and accounting counsel to correct your mistake. They're gonna look to collect on that. Penalties, we've said it on many occasions, generally clients are gonna assume that any penalties they have are caused by you. They're gonna come after you. Interest paid. Interest, if you read this section on page 306, 307, sometimes there's 3 different positions with respect to interest. Some courts say no interest. Hey, you had the use of the money, no one gets interest. Some courts say, we're gonna give you all the interest on whatever monies you pay tax on, whatever the interest is, you can recover. And some say, hey, we'll take a middle ground. If you had the use of the money and now you have to pay it back and the IRS is charging you a higher rate, if you earn 2% and the IRS is charging 7%, you have to pay the difference, or 5%. So interest, depending on what state, these are, by the way, malpractice cases. Are they federal or state cases? State, okay? You get sued in state court typically, okay? So if you do something wrong, you're not in federal district court, guys. You are in one of the county courts, like in Essex County Court, or you're in Somerset County Court, or Hackensack. If you're in Bergen County, that's where people sue you under state law, state tort action, or state contract breach. And then beginning on page 307, 308, they talk about consequential damages, like suppose because the mistake, certain opportunities are lost. The authors give some nice examples. So there's consequential damages, and finally, in egregious cases, I've never seen this come up, putative damages. Yeah, there's only one sentence. I don't know of any case that I know of where there's been putative damages, but I guess in theory, there could be punitive damages, but again, I don't know any familiarity of that. Any questions about damages, guys? Page 309, column 6-6. Tax professional carelessly, don't like that adverb, guys, carelessly fails to report on the taxpayer's tax return dividend income totaling $34,000 from a single Form 1099 div. As a result of the discrepancy, the return is audited and questionable deduction of $30,000 in business expense, mostly for T&E, is disallowed. Similar expenses had never been questioned in prior years. Is the tax professional liable to the taxpayer for the additional tax, interest, and penalties paid to the IRS as a result of the failure to include the dividend income, a gross income, and the denial of deductions? Take a look. This could come up. This could be you. Hope it's not, but it could, because you're human, last I checked. People make mistakes. Devante, Nick, what do you guys say? Not sure? Nick?
Say yes,
Yes, what?
they would be liable.
Okay, and Brian, you agree, disagree?
I agree.
Why and how much? Okay, and John, you see if you agree with your colleagues here.
Because it was as a result of their error, of the preparer's error.
So just tell me what you would say is the damages here.
The tax, the added tax on the income, and then the penalties and interest.
But, Brian, agree, disagree, any refinement of that?
Yeah, I agree with that.
John?
Maybe add costs of corrective action.
Say again, Brian?
Maybe add costs of corrective action.
The cost of corrective action if new returns have to be done by another accounting firm presumably. John?
If the client gave him the expenses and said that they were like valid.
What,
business
if the
expenses,
client gave what?
The expenses.
Okay.
And said they were like legitimate business expenses, I don't see how the.
So you're distinguishing, you're saying, so does the accountant have any malpractice issues here?
I don't think so.
None. Kevin?
The fact that he gave that certain advice carelessly is a problem when it comes to potential damages and other sorts of things, and the consequential damages, like he said, of getting another accountant to do the work.
Okay, so this is Wednesday, it's an exam, so Dixie, final word? You have no final word. B, final word?
I think the practitioner, the professional is liable.
For what? Just be careful, for an
for the-
exam, that's not a very good answer, so you gotta be more specific.
Yes, for the additional tax, not for the additional taxes, sorry, for the interest and penalties paid to the IRS. Or at least the difference in interest versus what the taxpayer would have ordinarily have received. Unless,
But here's, that would be a B answer, can I give you the A answer?
yeah,
The B answer is, well, they'll be, everyone agree, liable for the penalties, right? Agree? Because they should have not carelessly missed. But interest, we could say, could, depending on the state, there could be 3 different responses. But the truly A answer would say, would delve into the issue of should the attorney, should the accountant be held liable for the T&E tax, the tax, interest, and penalties associated with the T&E expenses, right? Because isn't that the interesting element here? The dividend element, right, is not that interesting, because I think that's an easy one, right? The practitioner was foolish, did carelessly. The more interesting thing is, are these legitimate consequential damages? Because by that carelessness, did he open up, or did she open up a can of worms, right? Right? Isn't that the more interesting question? And what did the A answer delve into what to do under those circumstances? Or in other words, when I say delve into, express that there may or may not, depending on the state, be recovery, because this could perhaps be consequential. I would argue not. I would argue that the professional should not be held accountable for this, the T&E. It wasn't, they didn't do anything derelict. It was a position that the client presumably said was a business expense when it truly was a personal expense, right? But Tim Sayer might be up here and say, hey, that's what we call an eggshell plaintiff, where, hey, you did something wrong, and these are all the consequential damages that flow from here. So all I'm saying is, for an exam purposes, you would at least explore the difference between those two different spheres of practice. So we can say definitively. The second, sorry to leave your notes equivocal, I don't think there's a clear answer, okay? So it's not, I'm not saying there's no black and white answer, which is frustrating for some of you, most of you, but it is an issue. Problem 6-7. Taxpayer's warehouse was condemned to make way for a new freeway. Taxpayer received $5 million for the warehouse. Taxpayer's adjusted basis was $2.5 million. Goes to the size of the gain. Taxpayer consulted lawyer about how to reduce federal and state taxes. Lawyer incorrectly advised taxpayer if he reinvested the condemnation, the gain on the condemnation, he could defer the gain. Taxpayer brought a replacement property for $3 million and filed the tax return for the tax year deferring the entire gain. The IRS discovered the error when auditing the return, and the taxpayer was required to pay additional tax and interest on the tax on $2 million in capital gain, because you're supposed to reinvest the entire proceeds, not just the amount of the gain, right? So this is a real screw up, right? Bad advice.
Outside of this question, just for reference here, if they invested $4 million of it, let's say, only that $1 million is taxable, the rest of it is allowed to be deferred, right?
Yeah.
You don't,
Not
it's
allowed.
not an all or nothing.
Yeah, it's not all or nothing. Additional tax and interest were also paid to the state. Is the lawyer liable or accountant liable, whoever did this, for malpractice? And if so, what's the measure of the damages? So, I mean, by the way, Tim Say would go through, is there a duty? You know, just to remind ourselves, by the way, guys, I'll keep my hands on the page. You know, you would want to go through on page 299 at the bottom. Did the defendant owe the plaintiff a duty? And we would all say resoundingly, yes. Everyone agree? Because there is a client relationship here. Did the defendant breach the duty? Yes, everyone's nodding, yes. Because gave him bad advice, so there's a breach. Was it an approximate cause of the damage? Yeah, the client, the taxpayer wouldn't have had the interest, penalties, and tax but for this action, right? Everyone agree? So we got 3 out of the 4, and now the damages. V, what do you say?
I mean, the taxpayer would have had to pay that anyway, so.
Why do you
was
say that?
The capital gain, right? The tax on the capital gain?
Right, but if the taxpayer had been given the correct advice, maybe they could have deferred it and then died owning the new property, and 1014 would have eliminated the gain.
Outside of situations like this, are there really, almost always it's the taxpayer is still responsible for additional tax, right? So like, for example, the 6-6 one,
Right.
like, there's no question that the taxpayer.
I think the taxpayer in 6-6 would be responsible for the tax.
Yeah, that's what I'm saying, like, in situations where.
Generally, the
it's bad,
taxpayer is responsible for the tax.
Penalties and interest different, obviously,
Absolutely.
but additional tax, they gotta pay one. way or
Generally,
the
yes,
other.
except like a screw up on the alternate valuation date or a
Yeah,
problem
where
like this.
it could have been avoided.
Yeah.
Okay, so the rule of thumb is kinda like that, if it can be avoided, it might be, but if it couldn't have been avoided, they're always responsible.
Yeah.
Almost
All right, so here, guys, and V, I think you're retracting your own answer. Is that a fair statement?
Yeah, but how did you say could that tax have been avoided?
Well, if they had reinvested the entirety of the proceeds, then they could have deferred the gain. 1031.
Oh, in the warehouse.
Yeah, but they took the entirety of the proceeds and reinvested
Okay.
in new property for $5 million. They could have deferred the whole gain. Now, if I'm defense counsel, maybe I'd point out that for whatever reason, the client had other debts and they didn't have liquidity to reinvest the entire $5 million. You know, I don't know, but the defense here has got their work cut out for them. The bottom line is, for your notes, It's not gonna be easy to quantify the damages, but the additional tax, interest, and penalties, consequential damages, all sorts of things that are gonna come of this, both at the federal and state level, right? It's gonna be ugly. And again, guys, for you solo practitioners out there, to the extent you can, as smart as everyone is in this room, always try to, when there's real dollars at stake, make sure you have a network of friends to look over your shoulders and you reciprocate and you take whenever your friends give you issues that they have, you know, you need good friends in your practice, right? Make sure that you don't fall into the mud. Any questions here? Again, for your good news on the exam, I'm not gonna say I need a specific dollar amount, you know, and a judge, you know, there is no real specific dollar. You can make estimates, but specific dollar amounts are hard to come by here. All right? Defenses. Okay, now that we've learned what are the benchmarks for bringing a malpractice suit and damages, always good to know about what is the defenses. And like I said, this case that I'm working on that I was in New York City on Thursday morning for, opposing counsel is going hard and heavy into the statute of limitations lapsed, okay? And for whatever it's worth, they prevailed in one state court, and the plaintiff's attorney is hoping that the statute of limitations, and they're very confident that it hasn't lapsed in a different state. But if defense prevails in California where this case is happening, the case is over. These people would have spent 2 to 3 years that they've been working on this case, and may come to nothing. So statute of limitations is always a big issue. Statutes of repose is somewhat similar on that. You guys can read on page 310. Choice of law issues, again, depending on where the client is, where the law firm is, where the transaction happened. This gets into technical issues of civil procedure. For exam purposes, don't worry, I'm not gonna ask what state. You guys hopefully have a good knowledge of tax, you have a good knowledge of ethics issues. You can't be a jack of all trades. I'm just calling to your attention that choice of law issues can be pervasive, they can be a problem. Just be careful when you get clients out of New Jersey. That, again, you may find yourself in places like Wisconsin and other places during the polar vortex that you would prefer not being. Ripeness. I said to you that many of these tax shelter cases that I've worked on, clients are frustrated because they're angry. They're angry at their professionals. They're angry that the fees weren't disclosed to them. All sorts of emotions, and the clients aren't happy campers. Notwithstanding their unhappiness, until the case is resolved with the IRS, it's nearly impossible to bring a lawsuit. And I know it sounds strange, but at the time, and that can take, as you guys know, many, many years to resolve with the IRS. Sometimes they can't win because by the time they lose with the IRS, they may be in an awkward situation where the statute of limitations for bringing a tort action may have lapsed. So, but if they bring it too early, the court say, hey, the case isn't ripe. You don't know what your damage is. But many, many plaintiffs will bring a lawsuit, and if the court says it's not ripe, we'll hold the case in abeyance until the resolution with the IRS, until there's resolution with the IRS. So just know that. On 3-13, the authors raised the question, review the facts of earlier problems in this chapter. What problems were most likely to present statute of limitation or statute of repose issues under what circumstances? And, you know, there's no one definitive answer here. But anytime you have complex tax issues, particularly involving tax shelters and the dynamics with the IRS. That some of you who have had me for income tax or some of the other tax cases, periodically I call to your attention that tax returns were filed in, let's say, 1995, and we're reading cases at the appeals court level. The tax return was filed in 1995, and we're reading these appeals cases or sometimes Supreme Court cases in the year 2010, 15 years later. And recall, what is generally the statute of limitations issues? How long for professional malpractice in New Jersey? 6 years. So you see the tension that can create. But generally, when does the statute of limitations commence? Does it commence when the work is performed, when you perform your work, or when the damage is discovered? Typically, it's on discovery. So even though you screwed up in 1995 or 96 when you prepared the 1995 return, this may not let you sleep today, but even though you might think by the year 2001, 2002 you should be able to sleep, no, it may not be until the year 2015 is when the statute of limitations even then just commences. So the commencement of the statute of limitations is a tricky issue as well. So lots of things to worry about, but that's why people like John, how many espressos do you get?
5 over ice.
5 over ice. And people have heard me say this before, tax is not meant to be practiced with white wine, a goblet of white wine. John epitomizes the true tax practitioner spirit with a monster drink this morning and 5 espressos in the morning. He's a poster child and he's, maybe once he reads this chapter on malpractice, he's going to go for a 6th or 7th shot. All right, so the authors on page 313, 314 discuss privity. That's the issue I raised about this notion that you can't just sue anyone you want who commits an act of professional malpractice. Yet your client or the person has to be in privity with that professional. And the authors towards the end of the chapter just talk about conflicts of interest that we spoke about. That I guess Tim didn't really make as big an issue as he has done in the past. That probably one of the four, aside from you screwing up or me screwing up, something that conflicts. And remember, in my case, they really said I wasn't being sued because I made quote-unquote a mistake. They said I had a conflict of interest. At the end of the day, that was the meat and potatoes in my own malpractice cases, that they said I should never have transferred the deed to the wife, that in that circumstances I was remiss in my duties. I should have had the husband at that point, that it was unwaivable, that I should have had him have his own separate legal counsel, right? I disagree, but putting that issue aside. All right, so that brings us to the end of the book. Any questions about anything? Let me just make a few statements. Thank you, everyone. Wednesdays and Saturdays, I know it's not easy, 4 hours no less. I'm sure a lot of people say, how do you survive? And John could always say, espresso shots. Many of you haven't, so say thank you for coming. If you have 2 minutes, several of you have not completed the student surveys. If you have 2 minutes to complete those, that would be great. It will make, I think once you complete that, you will not get solicited again. For those who brought in food today or in prior classes, thank you for bringing in and contributing. And then just a reminder for those who came in late or didn't hear me, if you do have questions over the next few days, again, aside from Super Bowl will go from 6:30 to 9:30. Is that a fair statement on my part? Aside from this, and if the game is really bad, you can get me before the end of the game because I won't be watching it. I will see everyone Wednesday here at 5 o'clock, okay? So enjoy the weekend, enjoy the game. See you on Wednesday. All right, and V, thanks for taping. Omari, good luck.